Last night, Congresswoman Jaime Herrera-Beutler of Washington State issued a statement confirming that in the middle of the insurrection, when House Minority Leader Kevin McCarthy called the president to beg for help, President Trump responded, and I quote, "Well, Kevin, I guess these people are more upset about the election than you are." Needless to say, this is an additional critical piece of corroborating evidence, further confirming the charges before you, as well as the president's willful dereliction of duty and desertion of duty as Commander-in-Chief of the United States, his state of mind, and his further incitement of the insurrection on January 6th. We would like the opportunity to subpoena Congresswoman Herrera regarding her communications with House Minority Leader Kevin McCarthy, and to subpoena her contemporaneous notes that she made regarding what President Trump told Kevin McCarthy in the middle of the insurrection.
If they want to have witnesses, I'm going to need at least over 100 depositions, not just one. The only thing that I ask, if you vote for witnesses, do not handcuff me by limiting the number of witnesses that I can have. For the House managers to say we need depositions about things that happened after, it's just not true. But if he does, there are a lot of depositions that need to be happening. Nancy Pelosi's deposition needs to be taken. Vice President Harris's deposition absolutely needs to be taken. And not by Zoom. None of these depositions should be done by Zoom. We didn't do this hearing by Zoom. These depositions should be done in person, in my office, in Philadelphia. That's where they should be done. I don't know how many civil lawyers are here, but that's the way it works, folks. When you want somebody's deposition, you send a notice of deposition, and they appear at the place where the notice says. That's civil process. I don't know why you're laughing.
On the question of whether it shall be in order to consider and debate under the rules of impeachment any motion to subpoena witnesses or documents, the motion is agreed to by a vote of 55 to 45. Majority Leader.
Donald John Trump, by his counsel, is prepared to stipulate that if Representative Herrera-Beutler were to testify under oath as part of these proceedings, her testimony would be consistent with the statement she issued on February 12, 2021, and the former president's counsel is agreeable to the admission of that public statement into evidence at this time.
The managers are prepared to enter into the agreement. I will now read the statement. This is the statement of Congresswoman Jamie Herrera-Beutler, February 12, 2021. In my January 12th statement in support of the article of impeachment, I referenced a conversation House Minority Leader Kevin McCarthy relayed to me that he'd had with President Trump while the January 6th attack was ongoing. Here are the details. When McCarthy finally reached the president on January 6th and asked him to publicly and forcefully call off the riot, the president initially repeated the falsehood that it was Antifa that had breached the Capitol. McCarthy refuted that and told the president that these were Trump supporters. That's when, according to McCarthy, the president said, "Well, Kevin, I guess these people are more upset about the election than you are." Since I publicly announced my decision to vote for impeachment, I have shared these details in countless conversations with constituents and colleagues and multiple times through the media and other public forums. I told it to the Daily News of Longview on January 17th. I've shared it with local county Republican executive board members, as well as other constituents who asked me to explain my vote. I shared it with thousands of residents on my telephone town hall on February 8th. Mr. President, I now move that the Senate admit the statement into evidence. Say you light a fire, and you're charged with arson. And the defense counsel says, everything that I did after the fire started is irrelevant. And the court would reject that immediately and say, that's not true at all. It's extremely relevant to whether or not you committed the crime. If you run over and try to put out the flames, if you get lots of water and say, help, help, there's a fire, if you call for help, a court will could infer that you didn't intend for the fire to be lit in the first place. They would accept your defense, perhaps, that it was all an accident. It was an all accident. Accidents happen with fire. But if, on the other hand, when the fire erupts, you go and you pour more fuel on it, you stand by and you watch it gleefully, any reasonable person will infer that you not only intended the fire to start, but that once it got started and began to spread, you intended to continue to keep the fire going. And that's exactly where we are, my friends.
This has been perhaps the most unfair and flagrantly unconstitutional proceeding in the history of the United States Senate. For the first time in history, Congress has asserted the right to try and punish a former president who is a private citizen. Nowhere in the Constitution is the power enumerated or implied. Congress has no authority, no right, and no business holding a trial of citizen Trump, let alone a trial to deprive him of fundamental civil rights. Their story was based not on evidence, but on the sheer personal and political animus. The flimsy theory of incitement you heard from the House managers could be used to impeach, indict, or expel countless other political leaders. Many leading figures in other parties have engaged in far more incendiary and dangerous rhetoric. And we played some of it. I'm not going to replay it. I'm not going to replay the words. You all saw the evidence. I'm not going to replay mob scenes. I don't want to give those people another platform, any more view from the American people as to what they did. They should be canceled.
The yeas are 57. The nays are 43. Two-thirds of the senators present not having voted guilty. The Senate judges that the respondent, Donald John Trump, former President of the United States, is not guilty as charged in the article of impeachment. The presiding officer directs judgment to be entered in accordance with the judgment of the Senate as follows. The Senate, having tried Donald John Trump, former President of the United States, upon one article of impeachment exhibited against him by the House representatives, and two-thirds of the senators present not having found him guilty of the charge contained therein, it is therefore ordered and adjudged that the said Donald John Trump be, and he is hereby acquitted of the charge in said article.
Mr. President.
Majority Leader is recognized.
Mr. President, I send an order to the desk.
And the clerk will report.
Ordered that the Secretary be directed to communicate to the Secretary of State as provided by Rule 23 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, and also to the House of Representatives, the judgment of the Senate in the case of Donald John Trump, and transmit a certified copy of the judgment to each.
Without objection, the order will be entered. Majority Leader.
Mr. President, I move that the Senate, sitting as a court of impeachment on the article against Donald John Trump, adjourn sine die.
And without objection, the motion is agreed to. The Senate, sitting as a court of impeachment, stands adjourned sine die. And